Get ready for the dictation. Start. It is only when such finding is found to be against any provision of law or evidence, or is found to be wholly perverse to the extent that no average judicial person could ever record such finding, it would not be held binding on the superior court. When the question arises as to what is the status of a workman, this court has held that it has to be inferred as a matter of law from facts found, and if the question involved is one of drawing a legal inference as to the status of a party from facts found, it is not a pure question of fact. It is held that if the inference drawn by the tribunal in regard to the status of the workman involved the application of certain legal tests, it necessarily becomes a mixed question of fact and law. The court has, however, cautioned that it must be remembered that even if the question raised is one of the mixed question of fact and law, this court would not readily interfere with the conclusion of the tribunal unless it is satisfied that said conclusion is manifestly or obviously erroneous. With a view to examine the question from both angles, which is taken note of above, we perused the evidence and also called upon the parties to file additional evidence before the court, and it was filed. Having perused the record, we are not inclined to interfere in the finding recorded by the High Court, though of reversal. In other words, we are inclined to agree with the reasoning of the High Court and accordingly hold that the total strength of workers employed at the relevant time in respondent numbers 1 unit was 99, and that the status of 16 disputed employees could not be conclusively proved to be that of a workman for the reasons stated infra. First, the High Court assigned the reasons as to why the finding of the Industrial Court holding the strength of workers as 115 is not factually and legally sustainable. Second, the reasons assigned are neither arbitrary nor against the record and nor perverse to that event so as to call for any interference by this court. Third, in these circumstances, this court would be slow to appreciate the entire evidence afresh on this question in this appeal, and lastly, such being a question of fact or a mixed question of law and fact, it is binding on this court. In spite of this, we have gone through the evidence with a view to find out as to whether the High Court has committed any jurisdictional error in reaching to its conclusion. In our view, it is not. We notice that the Industrial Court held that there was no dispute regarding the status of 79 workers. The dispute of status of an employee was confined only to 36 employees, namely whether their status was that of the worker or supervisor. The Industrial Court, however, held that the status of all the 36 employees was that of worker and accordingly recorded a finding that 79 plus 36 is equal to 115 employees were working as worker in the unit at the relevant time. The High Court, however, while reversing the aforementioned finding of the Industrial Court, came to a conclusion that out of 36 employees, only 20 employees could be regarded as worker, and therefore the total strength of workers at all relevant time was 79 plus 20 is equal to 99. In our opinion, the High Court rightly held that there was no cogent evidence adduced by the appellant to prove the status of remaining 16 employees as to whether they also could be regarded as worker employed in the unit, and therefore it was not possible to hold that the total strength of the workers at the relevant time was more than 100, that is 115. We, while concurring with the reasoning of the High Court, also find that since the Industrial Court did not elaborately discuss the issue regarding the status of 16 employees while holding the strength of workers at 115, except clubbing 36 with 79, the High Court was right in going into the evidence to the extent permissible and reversed the finding of Industrial Court. In our view, the Industrial Court should have examined the status of such disputed employees independently for holding whether they could also be regarded as worker. It was, however, not done so. Stop.